Okay, we got it. All right, well, since everyone's assembled, the time is 1 p.m. or thereabouts. We'll get started. I call to order the September 18, 2024 meeting of the Legislative Committee of the Contractors State License Board. I am Joël Barton, Legislative Committee Chair. Please note that only board members who are members of the Legislative Committee may participate in the committee meeting. Other board members who are in attendance may observe but cannot ask questions or participate in the discussion. The purpose of today's meeting is to provide a public forum to discuss if there are ways to provide additional consumer protection for residential construction in the Contractor State License Law. Because the teleconference committee meeting is remote, committee members cannot make recommendations or motions. However, committee members can gather information, receive comments, and legislative suggestions. Committee members will be using cameras during this meeting. The law requires committee members participating in this meeting to have their cameras on. Please have your camera on for the duration of the meeting. When you would like to comment during the meeting, please select the raise your hand icon in the WebEx application. Our moderator will call on committee members to speak. When called upon, please unmute yourself, and when finished, return to mute. Robin, please call roll and confirm we have a quorum.
Joël Barton.
Here.
Rodney Cobos.
Here.
Miguel Galarza.
Here.
Amanda Gallo.
Here.
Diana Love.
Here.
Thomas Ruiz.
Here.
We have a quorum.
Thank you, Robin. At this time, I'd like to ask everyone to please rise. We'll open the meeting by reciting the Pledge of Allegiance. And please, as you recite it, remember all those who have served and all those who are currently serving to protect this great country of ours. So if you'd cover your heart with your right hand and repeat after me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. You may be seated. CSLB staff participating in today's meetings include Registrar David Vogt, to my left, Chief Deputy Registrar Michael Jamnetsky, over there, Legislative Chief Rebecca May, to my right, Information Technology Chief Jason Perez, and Executive Office Staff Robin Williams, who will be taking roll. In addition, we are fortunate to have with us John Kinn, Esquire, DCA Board Counsel, and Yvonne Durantes, Assistant Deputy Director, DCA Board and Bureau Relations. I understand we have representatives from the Office of Assemblymember Grayson and Assembly Business and Professions Committee. We appreciate their commitment to assisting their constituents, and we welcome them. I also understand there is television news media present as well, ABC 10 Sacramento in the back or right here. The law allows audio or video recording as long as it does not obstruct or disrupt the meeting. Slide 3. Next is agenda item B, our public comment section. This item is provided for public comment pertaining to items not on the agenda. As you are aware, today's meeting serves as a forum for the public. CSLB always welcomes and encourages public feedback. However, because this is a public meeting, the law requires us to adhere to a few rules. First, and most relevant to this meeting, if you have a pending application, pending complaint, or pending disciplinary charges before the board, please do not discuss the specific details of your case. Committee members and board counsel are not permitted to receive evidence or information outside of the administrative record in a case. This is considered ex parte communications and may jeopardize the board's investigation and enforcement efforts. The committee can receive comments regarding the complaint and enforcement process in general, or recommendations for additional consumer protections, but please refrain from providing any identifying information or facts of a particular case. CSLB greatly appreciates you adhering to this rule. Enforcement staff are present at the meeting today to meet individually with any consumers that may have complaint-related concerns. If you want to meet with staff individually, please provide your name to Katie. Where's Katie? Right there, all right. And she's not in the back room, she's at the table. Thank you, Katie. If you are participating virtually, please add your name and contact information in the chat room. You can send a confidential message to the moderator. If you have a pending complaint, it may be necessary for the assigned investigator to contact you at a later date. State law also prohibits committee members from discussing any matter brought up during public comment or acting on any item not on the agenda. If you want the committee to discuss a topic not on the agenda, you can ask the committee to consider placing that issue on the agenda of a future meeting. If your comments are related to a specific agenda item, please wait until that item comes up for discussion rather than discuss the item during the general public comment section. We will ask for public comment on each agenda item. Lastly, to allow this committee enough time to conduct its full schedule of business, public comments are limited to 3 minutes apiece. Information Technology Chief Jason Perez is our host and moderator today. He will assist us by monitoring public comment through the WebEx application. Members of the public who would like to comment at any time during the meeting, please select the raise your hand icon in the WebEx application or leave a message with the chat feature. First, I will ask if any committee members have any items they would like to place on a future meeting agenda. Any committee members present on WebEx? Seeing no additional comments from the committee members, I will now turn to general public comment for this agenda item and future agenda items. I will start with members of the public here in the room and then move to members in the public attending via WebEx. Are there any members of the public here in the room who wish to address the committee regarding items not on today's agenda or to offer an agenda item for a future meeting? Anyone in the audience? Yes, please come to the mic.
Before you get started, can you please state your name so we can accurately record your name and your comments?
Absolutely.
Thank you.
My name's Andrea Montano. My name's Andrea Montano. Is that better? Yep. Press the next button. Test, test. Okay. Thank you, everyone. My name's Andrea Montano, and I will start off by saying I have a heart condition, so public speaking sometimes can be difficult. I am here representing a wide variety of folks as an admin of a group called Scammed by Anchor Tiny Homes on Facebook. We're a collaboration of customers and employees, contractors, subcontractors, and franchise owners that have been defrauded of over $30 million and counting dollars in different varieties of ways from Anchor Tiny Homes. I'm one of the first customers that was scammed by Anchor Tiny Homes back in 2021. I do not have a case with CSLB as my case has been resolved, but I come here before you guys because I want to not only show you guys that there is so much more than what CSLB knows of, and we're hoping that we can use this platform to also help the local district attorneys, the Office of Attorney General, and local law enforcement, the FBI, IC3, and everyone that we have tried to reach out to help us. We feel like we've been on a high-speed chase for over 2 months now, and we're the only ones following the getaway car. So as you hear more about the egregious, fraudulent, embezzlement, laundering, abuse, elderly claims, and all of the stories that will come before you, whether they are complaints that are with the CSLB or people that have not come forward, there has been some major, major crimes that have happened here in our capital region, and we really hope that we can get swift action to help us all bring them to justice. Thank you for your consideration.
Thank you, Andrea.
Move on to item C.
Thank you, yeah.
Should just-
Are there any other further items not on the agenda in the audience?
They don't relate to Anchor Tiny Homes.
Yeah, and this is, again, this is not related to Anchor Tiny Homes. This is items not on the agenda. Okay, I'll be calling for comments on the item. Any on WebEx that would like to bring up any items not on the agenda?
Yes, I do have a few on WebEx. Amy Pierce, I am unmuting your line.
Okay, Amy?
California attorney.
Turn off
I with, I'm a partner with Lewis Brisbois, Bisgard and Smith LLP.
We can't hear you in the large conference room.
I'm sorry? Hi, my name is Amy Pierce. I'm an attorney in California. I represent contractors in California and elsewhere. I've been working with the licensing board and contractors for more than 20 years. I would like the committee to put on its agenda an issue item in connection with a case decision that was recently issued by the Second Appellate Court. This is a Court of Appeal in Zale v. Levan. The Court of Appeal was looking at and interpreting the contractor state license law, and its interpretation of this law appears to be contradictory to positions that the Contractor State Licensing Board has taken and maintained for many years. In particular, the court interpreted the term contractor under section 7026, and there were essentially three issues that the court was addressing. One of them was whether or not if something that is installed is removable, whether a contractor's license is required. The particular context of this dispute was there was a window coverings contractor that installed more than $30,000 worth of window coverings that included motors, and the Court of Appeal endorsed the jury's finding that because these window coverings were installed with screws, they are removable and therefore no contractor's license is required. I believe this runs completely contrary to the way the licensing board views the installation of home improvement goods. As we all know, most items that get installed are not permanent. They are removable. People often do home remodeling projects. The Court of Appeal somewhat disregarded that the licensing board has included in its classifications a C61 D52 classification for window coverings contractors, among other classifications that covered the scopes of work that were at issue here. One of the other issues that I think is important for the licensing board is the appellate court appeared to endorse the idea that an unlicensed contractor could direct the home, could solicit bids, solicit contractors, review the bids, review the work, and if they directed the homeowner to pay the subcontractor directly, pay the unlicensed contractors directly, that this somehow made these subcontractors and these contractors the homeowners contractors as opposed to the unlicensed contractors, subcontractors. One of the other issues that I think is troubling in this day and age is that Ms. Zale referred to herself as a interior decorator. Because she didn't call herself a contractor or a subcontractor, the court was very lenient in the way that it referred to the supervisory work that she did.
Okay, thank you, Amy.
Bids.
Thank you for your request. The board consider a future agenda item. Please place this request in writing addressed to Board Chair Michael Mark and mailed to CSLB Headquarters Executive Office, and it will be reviewed and considered.
Thank you so much.
Thank you. Do we have anyone else on WebEx? Jason?
Yes, I am unmuting Kathy Wynn.
Okay, Kathy.
Go ahead, Kathy. We show her mic unmuted. Hello, Kathy. We're not able to hear you if you are speaking.
Hi, can you hear me?
Yes, we can. Go ahead.
Okay. I think just the request that we had was, I know we know that California had recently had grants for ADUs in the past couple of years. We were thinking that possibly in the future, if there are going to be grants that are going to be made available, if there's something that, this situation could have, I guess, a priority or a notice so that we can apply for this grant to possibly help us with the restitution goals.
Okay, thank you, Kathy.
Sorry, I'm not sure if you guys got all that.
Thank you.
All right, thank you,
Thank
Kathy.
you.
For your request, the board consider a future agenda item. Please place this request in writing addressed to Board Chair Michael Mark and mail it to CSLB Headquarters Executive Office, and it will be reviewed and considered. Jason, do we have anyone else?
Yes, we have Vivian Wong. Unmuting your line right now. Go ahead.
And I have a swimming pool complaint that this is the second go around, and the first part of it was last year. The contractor was resolved through arbitration, and now is the second contractor doing the repairs has abandoned the project, and the board is in the process of trying to close out the case, and I need your help to evaluate this more thoroughly because the industry expert that the board provided gave an estimate. and
Ms. Wong?
there wasn't-
This is John Kinn, counsel for the board. We'd rather you not explain your specifics of a pending complaint because only a part of the board is here today and they can't hear specifics of ongoing complaints. If you'd like, I think there's
Contact them in the chat room.
Yeah, if you put your contact information in the chat room, someone from enforcement can get in touch with you and discuss your case and the specifics.
Okay, I just want the board to not close out the case, and for future, a contractor that is license suspended, what is the procedure in terms of filing a complaint? Because had to wait for that. And then when the industry expert provide numbers, there's no justification, line items of what it includes. So just want more transparency to help to protect us as the consumers.
Thank you. And you can discuss your specifics with the enforcement staff.
All right, thank you.
All right, thank you. And John, would it be more appropriate for tomorrow her to speak during general comment or not just a comment with her educator?
Yeah.
We need her to talk to the investigator, the supervisor.
Okay.
Yeah.
All right, thank you. Do we have anyone else on WebEx?
Yes, we do. We have Richard Markinson. I unmuted
Good
your
afternoon,
line.
Board. It's Richard Markinson, representing the Western Electrical Contractors Association, the Plumbing, Heating, Cooling Contractors of California, and the American Fire Sprinkler Association and the Independent Roofing Contractors of California. With the enactment of AB 2622 by Assemblymember Carrillo, which deregulates construction projects under $1,000 from the purview, I'm paraphrasing, of the CSLB. But from the perspective of my clients, this bill, because it only modified Business and Professions Code 7048, created a variety of loopholes in other B&P code sections that are applicable to licensed contractors. For instance, 7090, 7152.2, and others that trigger a variety of requirements and obligations for contractors for projects above $500. So my clients would like to suggest that the CSLB consider proposing possibly for the Omnibus Business Professions Bill next year, legislation that would correct these inconsistencies and bring into comedy or similar language for licensed contractors and unlicensed construction workers, so that there is not an unlevel playing field that completely ignores any work by an unlicensed contractor of under $1,000, yet subjects a licensed contractor to a variety of requirements and obligations for contracts between $500 and $1,000. So that's my request. I'll be happy to put that in writing and share it with the chair. And thank you very much for your service to consumers and contractors, and for allowing me to share my clients' perspectives.
I appreciate that, sir. And yeah, if you would send that request in writing and then also reach out to our legislative director, Rebecca May, to my right, that would be greatly appreciated. All right, thank you. Do we have anyone else on WebEx?
Yes, we do. We have Connie Arnold. I am unmuting your line. Go ahead.
Can you hear me?
Yes, we can.
Oh, okay, thank you. Thank you very much for the opportunity to speak. My name is Connie Arnold. I'm a disability rights advocate, and I just had some comments regarding items not on the agenda, as well as the item related to the accessory dwelling units. And first off, I wanted to say I find it problematic that Find My Contractor does not have any category for specialization of individuals who specialize in residential home renovations for persons with disabilities, such as roll-in showers and things like that. I understand that all contractors are supposed to know these things, but some individuals do specialize in that. Additionally, as it relates to the proposal concerning the accessory dwelling units, I'm very concerned about anything that would require a bond and a payment of that for homeowners with disabilities and families with disabilities that are trying to keep their loved one on the property with them for aging in place, because that will make it more cost prohibitive for such individuals to undertake accessory dwelling units. Let's see, I had one more comment, which was that the government code 4459 that says that the division of the state architect has to maintain building codes that don't increase or enhance accessibility needs to be changed, because there is so much technological innovation happening, including building situations like glamping for like camping, that sites that are not accessible, zip lining accessibility, because that can be made accessible, electric charging stations requiring access for persons possibly with disabilities. And the codes are not such that it addresses any enhancement or increase in access other than maintaining our existing Title 24 codes and building standards, and not doing less than minimum standards in the ADA. That's problematic. I'd like to see that addressed in legislation. And I'd be happy to talk to anybody after the meeting. I'm going to put my information, my phone number, and my email in the Q&A box. Thank you very much.
All right, thank you for that request. If you put that in writing and send it to the chair, Michael Mark, here at the headquarters, CSLB headquarters, we'd, greatly appreciate that. Anyone else on WebEx?
Can somebody put the address in?
We're going to keep track of all this that relates to ADU, so they wouldn't need to send it.
Okay.
We'll be.
All right, thank you.
Thank you.
Anyone else? Jason?
We have no one else
It
at this
doesn't
time.
relate to ADU.
Okay, thank you very much. We'll end that portion and,
Wait, Joel.
oh, yes. Is this
Unrelated.
something not on the agenda?
Yes. Good afternoon. My name is Can you guys hear me? Good afternoon. My name is Carlos Lupiano. I'm here on behalf of my dad, Armando Martinez. He owns MC Construction. And I wanted to tell the board if we could, I have some concerns on subcontractors who lack protection on contractors not paying us. We were owed money by a builder. And so we wanted protection for subcontractors. Because the other route to go was to put liens on people's properties, and that's not fair to the property owners who've paid the general contractor. So I would like to more protection for subcontractors. Thank you.
Yeah, we appreciate that. We will be looking into that. Appreciate your comment. All right, anyone else from the audience? All right, so now we are now moving on to agenda item C. At today's meeting, the committee is looking for feedback from the public regarding laws applicable to licensed contractors engaging in residential construction, whether that is home improvement or the construction of single-family dwellings. I will now turn it over to Registrar David Folk to explain the board's role in protecting consumers through the home improvement business contractors laws, and to provide background information on some legislative concepts identified by staff. David?
Thank you, Chair Barton, and I want to thank all of you for attending the meeting today. I know that you're attending this meeting because you do have a complaint against a licensed contractor that has not completed your projects. That's what we're hearing. Has taken significant amounts of money and failed to complete the contract, which is very troubling. I just want to lead by stating that public protection is the highest priority of this board, and so we really look forward to hearing about your suggestions. If we have legislative improvements, we want to consider them. We have staff here that will be taking note of your suggestions, so you won't need to put those in writing. We should be able to capture that at the meeting today. What I wanted to do, though, to begin with, is just provide some background information. If we could turn to the next slide. And the next slide, please. When we talk about accessory dwelling units, they can be either a conversion of a garage into a living quarters. It could be an attic, it could become an apartment. But I think most of you are here today because you've contracted for what we'll call ADUs in a residentially zoned area to put an ADU on property that you own. It's not directly connected to the existing structure. I think that's probably a true statement. Next slide, please. I mention that because our board takes very seriously home improvement payment restrictions. In California, if you're a contractor and you're performing home improvement work, you're restricted to not receiving, you get a $1,000 deposit, nothing greater than that, but you're restricted to not receiving payments that are greater than the value of work and material supply. We have another slide that covers that. Now, if you look at 7164, this statute relates to new home construction. At some point, the legislature created this statute, and they must have taken the position that if you're building a new home, that you don't need the same protection that you would need if you're remodeling an existing structure, because 7164 doesn't restrict payments. You could pay your contractor 100% up front if it's for a new home construction. And after we've received complaints, we have looked into building department requirements, and we understand that many building departments consider ADUs to be new construction. So there may well be a need to clarify that an ADU is not construction. I know we have some staff that are watching this meeting today. I want to reference a government code that clearly states that an ADU is a living facility that's attached to or detached on the same property is considered to be home improvement. We do consider it administratively as home improvement. And I'm going to show you in a minute why that's important. Now, one of the lead-ins on this, and if you looked at, I'm sure you looked at the agenda, is whether we need to clarify in law that an ADU that's not directly connected to an existing structure is home improvement. Probably do need to do that because there is confusion, and If you're to file a case criminally, we may need that clarification. We do not believe we need it administratively to hold a contractor accountable for violating administrative law. So can we turn to the next slide? This is a very important slide because, as I mentioned previously, in California, you're granting credit to your customer, to your homeowner. The idea is you can get a $1,000 deposit, but if you're not going to get paid until the completion of the job, then the payments cannot be greater than the work that's being paid for. And I know that many of you here have made a second or third payment for a significant amount of money, sometimes for plans that you don't have, maybe for a permit and some type of fees that you don't know were paid. That's a problem. This law kicks in. And that's why we need to be clear that ADUs in residentially zoned areas are considered home improvement. Now, a contractor can take 100% up front if they have what's known as a payment and performance bond. Very few contractors have that, and the contractor that you contracted with did not have a payment and performance bond. So let's move on to the next slide. Here I just I want to emphasize that the Contractors Board has administrative authority. We establish qualifications for licensees. We have the ability to administratively take disciplinary action against a contractor's license, and that often includes the revocation of the license. That's what we can do at the Contractors Board. We can take administrative action. Now, when you look at violation of payments, you look at abandonment, not completing the contract, were funds misused? Did you pay money to a contractor and that money went elsewhere? It didn't go towards your project? That's misuse of funds. Do you have sufficient funds left in your contract to complete your contract? Many of you do not. That's all grounds for revocation of the license administratively. Now, turn to the next slide. Criminally, and that's why we need to be a little bit careful today, I think as Chair Barton pointed out or mentioned, we do have enforcement staff here, because violations that can be addressed administratively often can also be addressed or referred to a local prosecutor, that being a district attorney, for criminal prosecution. And we cannot be discussing an investigation that may result in a referral to a district attorney, because we do not want to compromise it. So when you think about making your comments today, I would ask that you do so in a general sense. You look for opportunities maybe to help us to support legislation that could better protect consumers in the future, could tighten up the laws. But if you want to talk about your specific case, or you have a concern that it's not being publicly disclosed, you would want to discuss that with enforcement staff separate from this public meeting. So we are prepared to open that avenue for you. Okay, next slide, please. I included this slide because in the event you have a contractor that has filed for bankruptcy or may file for bankruptcy, this could be helpful. 484B is the penal code statute that is most commonly investigated here at the Contractors Board. What it says is that if a contractor requested and received money for a specific construction purpose and it went elsewhere, it didn't go towards that purpose, that would constitute a violation of 484B. So you need to be aware of that. We're not able to discuss, or give legal advice or certainly discuss bankruptcy law here, but in the event that you would like information regarding bankruptcy, I went to the internet and I found a really interesting document. It's called Bankruptcy Basics. So you could look at that. It has a lot of information that discusses the federal bankruptcy code. But this would be a section of law that will be investigated, that is investigated by the Contractors Board when we receive complaints that people have paid money for specific construction projects and it didn't go towards that project. Next slide. So this is one, when you look at this slide, and I'll be honest with you, this was educational to me yesterday when Mike Jemnetsky brought to my attention that if you look at the bonding requirements for a limited liability company, what you'll see is that limited liability companies have additional bonding requirements. Every contractor is required to have a $25,000 bond. Now, limited liability companies are required to have an additional $100,000 bond, but it's limited to employees and workers. How does that help you as a consumer? I mean, that's something we ought to really take a look at, I think. Why isn't the consumer, first and foremost, someone that could try to collect on that bond? And then liability insurance, that's not going to help. It's been our experience that it won't help when someone's taking money not performed. If they cause damage, what we call secondary damage to your house, the liability insurance could be beneficial. But should this be looked at? Should this be tightened up? Perhaps. Next slide. And again, these are just concepts that staff here at the Contractors Board have come up with for your consideration. You may have different ideas, you may have better ideas, and that's what we want to hear this afternoon. This slide just shows, it provides a description of different bonds. We have what we call payment of performance bonds. The law already says, encourages consumers and contractors to get a payment of performance bond when a contractor is taking progress payments. How are they helpful? Well, a payment bond ensures subcontractors are paid. The performance bond ensures that it's completed per the contract specifications. Now, why are they not very popular? Because it's been our experience that they add 2 to 4% to the contract price. So if you're entering into a contract to build a $200,000 ADU, do you want to spend $8,000 on a payment of performance bond? Probably not. But that's why we don't see a lot of those being obtained today. We're almost through this slideshow, so one more. Next slide, please. Now, many states have recovery funds. Recovery fund is where licensed contractors pay in upon their renewing their license into this fund. It could cost them on renewal. I've reached out to a couple of other states to find out how much the licensees have to pay, and it's approximately $300 every 2 years. But you could establish a recovery fund. Why do we not have a recovery fund in California today? In large part because we have around 245,000 licensed contractors, and they would rather not have to pay additional money on the renewal. Now, it's kind of a philosophical question. The majority of contractors do a great job. They don't take money and fail to perform the work. And what you have are the good contractors then paying for a few of the bad. But I can tell you that other states do have recovery funds, and it does provide an avenue for a consumer to seek legislation, or seek restitution, excuse me. So go to the next slide. I think it's the last one, and this is where we really do welcome any ideas that you have, any comments on what we just discussed, and if you have any additional ideas, we look forward to hearing them.
Okay. Thank you, Registrar Folk. I would now like to open this agenda item up for discussion by the committee members. Are there any comments or questions regarding the ideas already offered or any other possible ideas? I'll start with committee members in the room. Any? All right, how about on WebEx? Any committee members? Okay, seeing no additional comments by the committee members,
sorry.
I will now. Do we
Chair,
have?
Barton, we do have
Go
a
ahead.
public comment on WebEx. from
Go ahead, Mark.
Joseph
Is that Mark?
Perez. Joseph, go ahead.
Is that a board member? No. Oh, okay. Let me finish this as a general comment or general public. So I want to address the members in the room first. So I'll turn it over to those members of the public here in the room who wish to address the committee regarding this agenda item. Anyone, please step up to the podium.
Test, test. Thank you again. Andrea Montano. In regards to this agenda item, I would say one of the items that was suggested is perhaps a proportional to the concurrent liability would be suffice for surety bonds instead of raising it from a $25K to another minimum amount, being that there are some mom and pop small businesses, remodeling companies that are not necessarily working in large volumes, and that could detrimentally hurt those businesses. But for these larger companies that are franchising and they're carrying multiple millions of liability concurrently, perhaps carrying a surety bond that is proportional to that would be suffice, and having potential periodic reviews of those financials to make sure that they meet those That would be a recommendation from our group. And then something that wasn't mentioned, I'm not sure if this is in a later agenda item, but more protection around financing laws, whereas construction loans typically are held in escrow, and those payments are being monitored by a third party. We're with HELOC and sometimes other type of loans that are taken out for these types of projects. The monies are handed over to the consumers directly, and sometimes they don't have the means or the know-how or the legal remedy to trust that when they're handing over these funds to the contractor, they think they're doing the right thing. They think they're doing what they're supposed to be doing. And so maybe tightening up some financing laws to help consumers now that are taking out ADU loans, that are borrowing against their 401ks, to help protect them in the future. Thank you.
Thank you very much for that. Anyone else in the audience? All right, thank you. Anyone on WebEx?
Yes, we have Joseph Retz. Your line is unmuted.
Hi guys, Joseph Perez, owner, general contractor of Neo Builders. We're a small ADU company that's building 15 to 20 ADUs a year. There are a lot of good ADU contractors. I think if we put payment bonds or performance bonds on every single ADU, that would definitely solve this problem, but it is very, very expensive, and most small contractors or medium-sized contractors will not be able to, number one, even apply for these payment and performance bonds. It's just too hard. They want so much financials. So I think it would be a really, really bad option. I do think that the fund that you guys were talking about is a good option. Maybe it comes from the contractors that are building ADUs. For example, taxing on another $100 per permit that is pulled for an ADU in each city or in each state. That might work out well. But I really do think that there are a lot of contractors that really want to make their entire business building housing and building ADUs, like me. And I think a good option for those people is doing a different license, for example, a C license or a D license that specifically are for ADUs. And then if you guys want to put easier terms, for example, on different bonds, or make it more challenging to take on way too many ADUs under that license, that is a good option. Or even make like the performance bonds or different bonds easier for that license. I think that's a really good option. But a secondary license for ADU contractors specifically will make it more challenging to jump in the game and have a ton of money and a ton of marketing and basically scam homeowners into saying like, I built so many ADUs. Like, let's get a license specifically for ADUs. Yes, sir.
All right, thank you very much. Do we have anyone else on WebEx, Jason?
Yes, we have Christopher Peterson.
Christopher?
Hello, yes. Can you hear me okay?
Yes, we can.
Yes, I'd like to address briefly, there appears to be a point where homeowners can be in double jeopardy where they have paid their contractor and then they have liens against their house for the construction, but the people filing the liens never get paid. I was wondering if it'd be worth considering for large payments on large projects that go to a contractor, if those could be put into an escrow account, and the contractors performing safe foundation work would put the lien against that escrow account instead of against the homeowner.
That's a good idea. Thank you for that suggestion. Is there anyone else on WebEx?
Yes, we have Douglas Washburn. Go ahead.
Yeah, I'm sorry, I can't quite hear everything here because of my hearing aid setup. But I wanted to follow up on the financial ideas that were previously raised. After a illegal demand for a billing of advance money before work is performed, a consumer coming to the bank to raise a fraud claim gets the pushback saying, oh, that was an ACH transfer, which was authorized by you, and they promptly close it without any investigation into the details of whether it was fraudulently billed. There should be some analysis and legislation around the banking industry and how disputes against this, also with respect to the 60-day rule versus 90-day kinds of rules for putting a claim against an ACH payment, needs to be rethought and probably legislated, because often the determination that it was fraudulent comes much later. Naive homeowners don't know all the ins and outs of these laws and rules, and then they seem to have no legal recourse against clawing back money from a contractor gone bad and off the rails. Thank you.
Thank you for that. Jason, anyone else on WebEx?
Yes, we have a Jared Bassler.
Jared?
Looks like we lost his audio. He lost his mic. We will return back to you, Jared, if you can address your mic issue. We'll go to Janine Carroll. Go ahead, Janine.
Hello.
Hello, we can hear you.
Okay, great. I have a couple comments, so bear with me if you would. Number one, just on the criminal matters, has the board referred anchored to the district attorney's office?
Could you repeat that? I couldn't quite hear that.
Sure. Has the board, have you guys referred anchored to the district attorney's office?
The legislative committee is not at liberty to discuss ongoing investigations. So I know it sounds like it's a little evasive, but it's not. It's to protect folks like you making complaints, not having your names out in the public. And I think Registrar Vogt said, and if he didn't, I'll say it, the CSLB is working with law enforcement on this issue and regularly cooperates with law enforcement on these types of investigations.
Okay, that's fair. I wanted to support the subcontractor who spoke. It is a double penalty. It's a double penalty for the homeowner, actually, when the general contractor screws the subcontractor, because the homeowner pays the contractor and then pays again. There's a huge problem there that has to be addressed, because there are all of these homeowners who are paying double. And the subcontractor, the ones who don't want to file liens, and they should file liens because they should get paid, but it shouldn't be the penalty of the homeowner. I cannot understand that for the life of me. And another comment I have about the insurance, I understand that there was a surety bond here, and we give people 30 days, even though they've been very deceptive. We give them 30 days to cancel that. I honestly feel that this is a board that's supposed to protect the public, and I feel like it was so slow doing that people lost a boatload of money in July and in June, and there was plenty of notice given by that point that something should have been done. There are homeowners who have lost money, and to me it's just inexplicable that it took this long to uncover the fraud. I say fraud. I understand you don't want to say it. I say it, but thanks for hearing my comments. And I think, you have to figure out a better way if you're truly going to protect the public.
Yeah, we greatly appreciate that. Anyone else on WebEx, Jason?
Yes, we have Katie Lucas. Go ahead, Katie.
Thank you. I wanted to speak on the fact that I feel like we found ourselves in this situation because of the lack of communication between the customer and our subcontractors. And I feel like if there was a law put in place where after 30 days of the subcontractor not being paid, they can communicate that or are made to communicate that with the homeowner. That way they can come to a quicker agreement or a quicker realization of who needs to be paid and why this happened, because so many months go on without the communication between the subcontractor and the homeowner. And I just think that that is something that needs to be changed.
Thank you very much.
And thank you.
Jason, do we have anyone else on WebEx?
Yes, we do. Laura Zanucci, I am unmuting your line. Go ahead.
Laura Zanzuki. I'm a homeowner. I'm an individual that was scammed by Anchor Tiny Homes for $40,000. I'm affected by all the issues discussed today. I appreciate you opening this forum for us to make comments. There's a few comments I want to make. Regarding the bond, the current bond regulations do not address the level of liability a large-scale company like Anchored Tiny Homes holds. The laws regulating this are insufficient and offer no solution for homeowners and other affected parties when a company engages in this type of long-term fraud. I respect the contractor's opinion. I don't think that every contractor's bond should be increased. I do agree with Andrea in saying that I believe there should be some equitability in terms of if you're taking on a huge liability, you're trying to sign up hundreds of customers and you say you have a financial stability of $100 million, that bond should not be $25,000. I work as a therapist, and when I opened my telehealth private practice, I had to have liability insurance to the tune of $1 million. So, and the thing is that my liability with one or two clients providing therapy online is essentially a data breach, right? And so I don't even have them in person. But to me, I cannot understand this bond law at all. I like a lot of the suggestions being proposed around I guess it was a contractor suggesting a separate licensing for ADU builders. That sounds promising. I hadn't heard of that before. And that's certainly with the restrictions that they're monitored more closely in terms of the contracts they take on, right? And I think they mentioned the marketing too. Marketing has to reflect what you're providing. So I appreciate you bringing up the bond issue. I do want to speak really quickly to recovery funds. Due to the bond issue and due to insufficient banking response, of course, there's people out $100 million and we're just trying to find ways to even recapture 10% of that. I'm sensitive to the fact that new contractors renewing their license should not take on that burden to fund that. But so if there's any other way to do it, to make it more equitable to the contractors involved, but I do think there needs to be a recovery fund. I also represent the Facebook group Scammed by Anchor Tiny Homes, and I did a poll of those members. It's about 1,000 of us, and recovery fund was the top issue, second to that prosecution.
All right, well, thank you very much.
Okay, thank you.
All right, and we have anyone else on WebEx?
Yes, we have Jason Comerford. Your line is unmuted.
Appreciate everyone's time here today. Specifically, I want to address the question regarding making subcontractors and/or material suppliers responsible parties in the necessitating payment from primary contractors. One of the biggest things that I've noticed throughout this entire process of my being scammed by Anchor Tiny Homes as well a significant period of time beyond their normal payment terms when they had invoices that were outstanding and past due, yet would continue to work, which generated some of the additional cost for many individuals. Specifically, a wood material supplier for my project ended up attaching a lien to my property, and their standard practice was they accepted that they would be paid 30 days past due and then trailing down to 60 days past due with their invoices. So they're accepting risk in the sense that, they're allowing individuals, if you're in a payment practice and your debtor doesn't pay you until you're past due for a certain period of time, you have to accept that there's risk associated with that. But to them, they did not accept any risk because they attached liens for every single one of those entities, those projects. What risk or responsibility is supposed to be borne by the subcontractor or material supplier for continuing to supply and or do work for an individual that has not paid them for a significant period of time? That being said, it's simply, if they're accepting risk of non-payment for doing work, that transparency should be borne somewhat the risk by the subcontractor, not only the homeowner.